Welcome
goes
back
with
to
you.
the courtroom,
No.
ladies and gentlemen.
This is a third violation,
Where the
Mr.
excuses are
McCollum.
loud,
It's not going to continue to
the patience
happen.
is thin,
All right, Mr. McCollum, good morning,
and the
sir.
bond violations are piling
Number
up.
one, don't
Today,
email
we are
me.
diving into a
That's not a
chaotic
good thing,
docket
man.
that has
Really,
everything a
you know,
legal junkie
'cause
could
it's-
ask for. We
I'm
have a
supposed to be
defendant
neutral,
facing terroristic
detached.
threat charges who
So
decided the best legal
I
strategy
don't know what
was
happens
to
until
personally
if it
email
goes to
the
trial.
judge.
So just
Spoiler alert,
it's okay.
that is a
but just from
massive
now on,
no-no.
all
We've
right?
got a man with a
So
GPS
you now
monitor
stand
that
charged. You picked
mysteriously
up a
died for
terroristic
3
threat
whole
of a
days,
family or a household
right as
member.
allegations
You're
of
facing
harassment
up to a
surfaced.
year in jail
You'll
and
hear
a
a defense
$4,000
attorney
fine.
battling to keep his
We're
client
going
out
to
of
do
jail by
probable
blaming
cause.
a
You have the
phone
right to remain
charger,
silent.
and a
Anything
judge
you
who
say can
literally
will be used
threatens to
against
grow
you. You have the right
horns
to have
and
an
a
attorney
tail
present.
if he
You
sees
cannot
another
afford one.
violation.
One will be appointed to you.
Plus, we have a
I
fugitive
don't
case
know
where
what
the
happened
other
in this
state
case.
literally refuses to come pick
I'm
the guy
just
up,
now seeing it for the
trapping
first
him in
time.
a legal
All I know
Groundhog
is that
Day.
you're on bond for
Buckle
this
up,
case. For another
because this
case, now you
judge is
picked up a new
handing
one.
out life
So
advice,
let's go forward. And
legal smackdowns,
Officers
and
were
some of the most
dispatched to a
colorful
residence in
warnings
Harris
we've
County,
ever heard.
Texas. Complaining
Let's
witness
get
showed
into it.
officer sex.
goes with you. No. This is a third violation, Mr. McCollum. It's not going to continue to happen. All right, Mr. McCollum, good morning, sir. Number one, don't email me. That's not a good thing, man. Really, because I'm supposed to be neutral, detached. So I don't know what happens until if it goes to trial. So just, it's okay. But just from now on, all right? So you now stand charged. You picked up a terroristic threat of a family or a household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I don't know what happened in this case. I'm just now seeing it for the first time. All I know is that you're on bond for this case, for another case, and now you picked up a new one. So let's go forward and shoot
Let's
up the
pause
house.
right here because
Was
this
that
is
from
courtroom
May and that he's
101
just
stuff that
investigating
just got
this?
broken.
Because that's not a
The
terrorist
judge
threat.
immediately
But if it was an
reprimands
active
Mr.
thing where
McCollum
he
for
was,
emailing him directly. In the
Like the
legal
offense-
world,
so,
this is called ex parte
Per
communication,
the offense
and it
report,
is
the actual
strictly
offense
forbidden.
took place on
Judges
November
must remain
8th.
neutral and detached. They
But I
cannot have
believe that
private
she showed
conversations
them
with the
old text
defendant
messages.
without the
okay, so
prosecutor present.
when was
When
that
a defendant
statement
emails
that
a
I'm going to
judge,
shoot up the
it
house and
compromises that
yada,
neutrality
yada, yada?
and can actually force a judge to recuse themselves from the case. Mr. McCollum is lucky
Sure,
the
take your
judge
time.
is letting him off
And
with a
Judge, while
warning
they're
here
looking,
instead of a contempt
it's not
charge.
alleged.
It shows
when
just how
the
unaware some
statement was.
defendants are of the strict rules of the legal system.
Not
Never
only that,
ever
it's
slide
not
into the
reported till 3
judge's
days
DMs,
later.
folks. It never ends well.
Officers were dispatched to a residence in Harris County, Texas. Complaining witness showed officers text messages ranging from May 2024 to November 2024, where the defendant sent her photos of guns and threatened to shoot the complaining witness and their child. Defendant also stated he would shoot up her house and hoped that he would hit her and the child.
When is the statement that he was going to shoot up the house? Was that from May and that he's just investigating this? Because that's not a terroristic threat. But if it was an active thing where he was, then,
Wow.
I mean,
Those
who
are
knows when
some
that statement was
incredibly
made?
heavy
Could have been made 2
allegations.
years ago. Could have been
We
made
aren't just
yesterday.
talking about a heated argument here. The state is alleging that
I
Mr.
agree with you, man.
McCollum sent
I mean, if you
photos
don't
of
have anything else,
firearms
then
and
that's
made
it.
specific threats to shoot up a house and harm a child.
Okay,
In
I'm going to
Texas,
find no probable cause. Mr.
Terroristic
McCollum,
threat charge requires the
we're
state
not
to
asking
prove
much,
that the
man.
defendant
We want our
intended to
streets to
place
be
the
safe.
victim in
I'm
fear
going to do
of
everything in
imminent
my power to
serious
protect the
bodily
streets,
injury.
right?
The presence
If I
of gun
find that you're a
photos
problem,
elevates this
they
significantly because it
call
suggests
back and it continues
capability,
to
not
happen.
just
It's
idle
not going
talk.
to go well.
This
Life
shifts
is
the
way
tone
too
of the
short to live in
hearing
a
from a
6x9
standard bond
box.
check-in to a
There are a
high-stakes
lot of
safety issue.
great people in
If
life.
these
There's a lot
texts
of
exist,
bad people in
the
life. And
judge
if
has
you
a
have a
duty to protect
relationship
the
with a
community,
so-called
which makes the upcoming
person that
defense strategy crucial.
brings out the
Let's
worst
see
in
how they
you,
try to spin
then don't
this.
have a relationship.
Well, it looks like the offense. So, per the offense report, the actual offense took place on November 8th.
Okay.
But I believe that she showed them old text messages.
Okay, so when was that statement that I'm going to shoot up the house and yada, yada, yada? Sure, take your time.
And Judge, while they're looking, it's not alleged when the statement was. And not only that, it's not reported till 3 days later. Furthermore, in the reviewing the text messages that have been submitted, there's not a single text message that
We
This is a
ordered him to have a
classic sharp
GPS
defense
monitor.
maneuver. The attorney is
We
attacking
admonished
the
you last
immediacy
time that
and
there
the
was
specificity
absolutely
of the evidence.
zero
He's
tolerance.
arguing that without a date
And
stamp,
now
the
we
threat
have
isn't
a
imminent,
third
which is a
bond
key legal element
violation.
for this specific charge. If the threat was from 6 months
What
ago,
was
the
the
law
nature
might
of this
view it
violation?
differently than if it was from yesterday. He's essentially saying, Judge, this is old news, and the state can't prove when it happened. It's a
So he had a
technical
dead
loophole,
battery.
but in a court of law,
How long?
technicalities matter. However, ask yourself this. If someone sent you a picture of a gun and said they were going to shoot your house, would you care if it was in May or November? The fear is real either way.
That has that specific threat.
Well, I don't know. I mean, it's the state's burden to show, I don't know, but terroristic threat has to be an immediate fear of harm.
So I don't see an actual date in the offense report. I personally have not reviewed the text messages in this case, Judge. I don't see a date of the actual threat.
That's not a good thing. I mean, who knows when that statement was made? Could have been made 2 years ago, could have been made yesterday. Yeah, I agree with you, man. I mean, if you don't have anything else, then that's it. Okay, I'm gonna find no probable cause. Mr. McCollum, we're not asking much, man. We want our streets to be safe. I'm gonna do everything in my power to protect the streets, right? If I find that you're a problem, if they call back and it continues to happen, it's not gonna go well. Life is way too short to live in a 6x9 box. There are a lot of great people in life. There's a lot of bad people in life. And if you have a relationship with a so-called
We are getting a rare moment of genuine fatherly advice from the bench here. Usually, judges stick to the statutes, but here he's stepping into the role of a life coach. He's telling the defendant that toxic
Judge,
relationships aren't just
this
bad for
complaining
the heart,
witness has been
they're
sending
bad for your
a
criminal
bunch of
record.
messages to
This
my
concept
client.
of
She's
situational
been harassing
criminality,
him.
where
I
otherwise
actually advise
Show
law-abiding
me.
people
I
commit
advise
crimes
show me.
only
I
within
did
the
ask her to
context
send
of a
me
volatile
screenshots of
relationship
everything, Judge.
is very
She said
We'll
real.
have a hearing.
The judge is
Show me.
trying to cut the
We'll have a hearing.
cord to prevent
Show me what
future
you got.
cases.
We'll have a hearing
But
over it.
notice
But
the pivot.
all I know
He's
is it's
dismissing
your
the probable
third
cause
bond
for the
violation.
specific new
I'm not
charge because of the date
happy
issues we
with you,
mentioned,
Mr.
but he's
McCollum.
keeping the bond conditions tight. He's giving him a break, but it's a warning shot.
Person that brings out the worst in you, then don't have a relationship with this person. There's a gajillion and one fish in the sea. It's not worth it to have someone rap you so bad that you make and say things that make you go to jail. It's not worth it. Do you understand? Now, don't have contact with this person because it's just not going to end well. All right. All right. So I'm going to continue bond. I'm not going to revoke your bond on this case now because I'm finding no probable cause, but just behave. It's not hard. Be nice. All right. Okay.
Judge.
For sure. Felicia,
Yes, Judge.
we ordered him to have a GPS monitor.
Yes, Judge.
We admonished you last time that there was absolutely zero tolerance. And now we have a third bond violation. What was the nature of this violation, please?
So it's that we lost cell on it, so either it wasn't charged properly or something of the nature, it's just.
And just like that, the tone shifts drastically. We went
I'm
from
not
no probable
buying it.
cause
I'm sorry,
on the
Hunter.
new charge to a
Goes with
third
you.
bond violation
No.
on the old one.
This is a third
This is where
violation, Mr.
defendants often
McCollum.
get
It's not going to
confused.
continue
You
to
can beat the
happen.
new case, but
With
still
all
go
due
to
respect,
jail for violating
this
the
is a
rules of your
technical
release on
violation.
the old
You
one.
shouldn't have to go
A
into
bond
custody.
violation
It's a
means you
third
broke the
violation,
contract you
Hunter.
signed with the court to stay free.
Judge,
The judge
it's
mentioned
clearly,
zero
just please
tolerance
stop talking.
previously.
Let me talk.
If this is truly the third
Judge,
strike,
it's clearly that
Mr.
there was
McCollum
an
is
equipment
walking on
issue, otherwise
extremely
they wouldn't
thin
have
ice.
replaced
The
the
court's
equipment.
patience is a finite
So
resource,
I don't
and it
see how.
sounds like
It'd
he's
be an
completely
excuse,
tapped out.
Hunter.
Let's see what
The
the
minute
excuse
you
is
have
for
an
this
issue.
one.
So he had a dead battery.
Yes. And
How long?
I'm sorry. I'm sorry, Judge.
Take your time. I'm in no rush.
If I may, if you would be willing to admonish the defendant as well. I spoke to the complainant yesterday, and apparently the defendant has been making posts about her on social media, bribing people with money to hurt her, and she's pregnant with their child.
Judge, this complaining witness has been sending a bunch of messages to my client. She's been harassing him. I actually advise.
Show me.
I advise.
Show me.
I did ask her to send me screenshots and everything, Judge, and she said.
We'll have a hearing. Show me. We'll have a hearing. Show me what you got. We'll have a hearing over it. But all I know is this is your third bond violation. I'm not happy with you, Mr. McCollum.
Judge, I saw that I don't think it turned back on at all from what I'm seeing on my end. But whenever he did report yesterday to have the device inspected, and they did just tell me that he did receive a new charger and new device.
When did it die? What's the date?
14th.
So from the 14th to today, when he got it back on, it's been dead.
He got it on yesterday, Judge.
Yes.
Well, it was on
To
yesterday.
the 17th. It's been dead for 3 days.
He called me yesterday and told me to go to pretrial and check out because
Your
they gave me.
device has been dead since December 14th.
Sir,
Okay,
they told-
stop
They
the
gave me a
tape.
new
Does
charger
anyone
and a
actually
new
buy
monitor.
this?
It's not like
The
a,
defendant
I didn't
claims his
mess up
GPS
anything.
monitor
As soon as
was
they
dead
called me,
for
I-
3
I-
full days,
Talk
from
to
the
your attorney.
14th to the
Judge, would
17th,
you
and he didn't
allow
know
me to
because
escort
he
him
thought
up
it was
to
charging.
felony court
These
so
devices
that
are
he
designed to
can
be
go take his
annoying.
plea today?
They vibrate, beep, and flash lights when the
The
battery
whole
is
reason
low.
they had
To
set
say
the
you
plea
walked
to
around for
after the
72
holidays is so
hours
that
with a
he
dead
could
ankle
do it after
monitor
the
and had
holidays.
no idea is
And I
the
believe
legal
part of
equivalent
this
of the dog ate
deal
my
would
homework.
see
The judge
this
knows
case
this.
go away.
When you are on
and he's gonna
bond,
be on probation for
maintaining
2
that
years
equipment
upstairs.
is your
So I
single
really
most
don't
important
see
job. Ignorance of the
benefit
device's
to
status is
society.
I mean,
rarely
if you want to go
accepted as
see
a
if
valid
that's
defense,
something that you guys can work
especially on a
upstairs,
third
I can
violation.
ask if,
I
and
wasn't aware of that, sir. I never knew my. They didn't give me no text or nothing. I was unaware of thinking it's charging. They gave me a new
And
charger.
Judge, with all due respect, he went there on Monday. He got, and they gave him a new charger and a new device. So it seems to me that it's a technical issue. So Judge, I would,
you're supposed to charge it on a daily basis. Am I,
Even in the pretrial, they charged it and they seen that it was charging, but it was still something messed up with the charger. So they gave me a whole new thing again.
how often is he supposed to charge it?
I think they're advised to charge once a day for at least an hour.
I'm not buying it. I'm sorry, Hunter. It goes with you. No. This is a third violation, Mr. McCollum. It's not going to continue to happen.
Judge, with all due
I
respect,
have-
Goes with you.
this is a technical violation. He shouldn't have to go into custody.
It's a third violation, Hunter.
Second, sir. It's my
Judge,
second.
it's
the first
clearly,
time.
just please stop talking. Let me talk. These
Ooh,
devices.
The
I've seen
tension
it
between the
multiple
attorney
clients
and the
where they're
judge
unable
just
to
spiked.
charge.
If,
Did you
if,
catch that?
if you see
The
it
attorney
on
actually
the
cut off the judge
14th
and said,
that you have issues,
"Let me talk."
then you
That
go
is a
immediately.
high-risk gamble.
You don't wait
While a defense attorney
3
has
to
a
4
duty
days
to
later,
zealously advocate for
especially
their client,
when you've had violation after
interrupting a
violation
judge
after
who is
violation.
already angry
I
about a
think that
third
your complaining
violation
witness
is
may
like
be here too.
poking a bear.
Rajette,
The lawyer is trying to
CW may
frame
be here
this
as well.
as a technical equipment issue rather than willful
So,
defiance. It's a
I
smart
don't know,
pivot.
Hunter.
If the machine is
Just-
broken, you can't blame the human.
Okay,
But the judge
ma'am,
is focused on the
please
delay.
don't.
Why wait 3
you
days
wanna-
to fix
I
it?
think pretrial has
That
something to
gap
say.
in
I don't know
time
what they
is
have.
where the suspicion lies.
Judge, it's clearly that there was an equipment issue. Otherwise, they wouldn't have replaced the equipment. So I don't see how.
It'd be an excuse, Hunter, the minute you have an issue, you're supposed to go get it serviced, not 3 days later. This is a third stop. This is a third violation. And I told you the last time when you were here with the baby that there was absolutely no tolerance, that you were supposed to live to the conditions. 100, it's been dead for 3 days.
I was unaware of that, sir. So when they called me,
Goes with you. Sorry, I'm not going to entertain excuses. It's zero
I'm not
tolerance.
giving you an excuse, sir. They gave me a new charger and a new monitor.
Judge.
It's not like I didn't mess up anything. As soon as they called me, I
Come on, talk to your attorney. Judge, would you allow me to escort him up to felony court so that he can go take his plea today? The whole reason they had set the plea to after the holidays is so that he could do it after the holidays. And I believe part of this deal would see this case go away. And he's gonna be on probation for 2 years upstairs. So I really don't see the benefit to
I
society.
mean, if you want to go see if that's something that you guys can work upstairs,
This is a fascinating strategic pivot by the defense.
I don't know
Realizing
what to
the
tell you,
judge is
Hunter.
ready
Judge,
to
it
revoke
sounds like
the
he was
bond and throw
overcharging.
his
He was,
client
he
in
was
jail
doing
today,
more than.
the lawyer suggests
required.
just moving straight
So,
to the plea
we
deal.
don't know that for sure.
He's
I
essentially
don't know.
saying, Your
See
Honor,
what
don't lock
documents
him up
that you
for
can
the
show me
violation.
that you can get
Let's
that
just
there's some
fast
kind of
forward to the
malfunction.
probation
But
sentence we
nevertheless,
already agreed on.
it's a third
It's a
violation.
damage control move.
On the
He
14th,
wants to
if he
avoid
has
his
issues,
client sitting in
perhaps
county
even go the
jail
next
with
day on
dead
the
time
15th.
waiting for a
But you wait
hearing.
3 days, and
He's
the only
trying to
reason he
skip
did
the
it is
punishment
because I
for the
hauled him into court
violation by
and I told him
merging
to
it
be
into
here
the
on the
final
18th.
sentence. It's a savvy move
Otherwise,
to
who
save his
knows what would have
client
happened.
from immediate
See what you
incarceration.
can find,
But
and
will the
then
judge
show
go
me.
for it when he feels
I'm all
disrespected?
eyes. I can ask if they'll escort him upstairs, but I can't continue to play this game, Hunter.
I understand,
You know,
Judge.
I mean, really, we ask you over and over and over to comply. I'm not asking for much,
I
right?
understand,
And
Judge.
it's been dead for 3 days. You know it's been dead because you're supposed to charge it. So you're supposed to charge it on a daily basis. So for you to come here and tell me I didn't know, it's disingenuous. It's just not true. So, but
My
I'm
frustration
happy
as
to
a
acquiesce.
attorney is I've seen this with multiple clients where there are technical issues that happen with these devices. I've seen it with multiple clients where they're unable to charge.
Hey, if you see it on the 14th that you have issues, then you go immediately. You don't wait 3 to 4 days later, especially when you've had violation after violation after violation. I think that your complaining witness may be here too. Rosette, CW may be here as well.
Judge, I'm not sure.
So I don't know, Hunter, just,
That's for a judge.
okay, ma'am, please don't. If you want to,
I think pretrial has something to say. I don't know what they have to
I
say.
reached out to my supervisor of these devices just because I'm not super well versed in the GPS realm, but he stated that the reports for his GPS appear to show an issue with overcharging, which can lead to a charger problem. They're instructed to charge for 1 full hour on the same time each day, and that the tech swapped his device as a precaution as it was likely that malfunctioning.
Here comes the technical breakdown. The probation officer is introducing the overcharging theory.
okay.
Apparently, leaving these devices on the charger too long can actually break them.
Get what records
If
you
that's
can,
true,
show me something.
that is a massive design flaw for a device that determines a
Guys,
man's
are you
freedom.
ready?
This gives the defense a legitimate foothold. If the defendant was trying too hard to keep it charged and broke it by accident, that's negligence, not malice. However, the judge brings it back to the main point. Even if it broke, why did you wait 3 days to report it? That 72-hour window of being
There are
off the
times in
grid
life
is terrifying
when
for
you
a
run
court,
into people,
especially with the terroristic
they
threat
can be a
allegations
complete
looming in the
cancer
background.
to your life. But why wait 3 days? You know the device is malfunctioning on the 14th. You're going to wait 3 days to go get it fixed?
I was just informing what my supervisor told me because I asked somebody to look over the report.
I don't know what to tell you,
I
Hunter.
mean, Judge,
You
it
know?
sounds like he was overcharging. He was doing more than
No,
required.
No, we don't know that for sure. I don't know. See what documents that you can show me, that you can get that there's some kind of malfunction. But nevertheless, it's a third violation. On the 14th, if he has issues, perhaps even go the next day on the 15th. But you wait 3 days, and the only reason he did it is because I hauled him into court and I told him to be here on the 18th. Otherwise, who knows what would have happened. See what you can find and then show me. I'm all eyes.
Well, Judge, the other thing I would ask is if you are going to take him into custody, I'd ask for a formal hearing to be set. And since this was set within less than 24 hours, I do believe it violates his due process to go ahead and take him into custody today. Yeah,
Just show me what you can find, Hunter. You know, Eddie.
Judge, real quick, Judge.
Right. Okay. Get what records you can. Show me something.
Okay.
Guys, are you ready?
Yes, Judge.
There are times in life when you run into people to
The
get
judge
away
is going philosophical again,
so that
and this is a
it
key
doesn't bring you
insight
down.
into his ruling style.
The
He's
problem
talking
is,
about
Mr.
cancerous
McCollum,
people and
is
drama. He
when
is
we
clearly
have
frustrated not
situations
just
where
with
there
the
are
defendant,
repeated bond
but with the
violations,
entire toxic situation
I
surrounding
take
this
issue with
family.
that.
By calling out
And I
people who
can't let
thrive
people
on drama,
go when they
he's
continue
acknowledging
to
that the
have
victim might be playing a
violations.
role in the
But I
chaos,
want to
but
know
he
that
stops
it's a
short of
true
victim
violation.
blaming. He's expressing a very human
I have ordered
frustration
him
with the
not to have
revolving
contact with
door
this
of
person,
domestic
correct?
disputes. This monologue serves a purpose.
Just,
He's
I'm not
explaining
asking
why
much
he is
from you.
hesitating to lock the
The
guy
only
up.
thing I'm
He
asking you to do is
suspects
stay
there
out
is
of
more
trouble,
to the story than just a
keep your
dead
monitor
battery,
on,
and he
and
wants to
don't have
see the
contact.
full picture before dropping the
And
hammer.
stop. I'm not, they can be a complete cancer to your life. Some people thrive on drama. That's how they get off. That's all they like. They like to just create. If you have people in your life like that, it's probably advisable to cut ties, because if not, they're just going to bring you down. We all have people like that in our life. We do. I do. I have people that are constantly after me as well. I do everything in my power to get away so that it doesn't bring you down. The problem is, Mr. McCollum, is when we have situations where there are repeated bond violations, I take issue with that. And I can't let people go when they continue to have violations. But I want to know that it's a true violation. I have ordered him not to have contact with this person, correct? Just, I'm not asking much from you. The only thing I'm asking you to do is stay out of trouble, keep your monitor on, and don't have contact. And stop. I'm not asking you to say, I don't like to put people in jail, but I got to know that you're complying with the conditions. There's a lot of things that are at play in your case here. There's a lot of other evidence that's out there that I would like to see before I take action and put you in. They're saying things that happen. Hunter is saying things that happen. I want to know what the truth is. And the truth is, and it lies with the evidence, because the evidence will point to whose side is correct. Words, Mr. McCollum, words mean absolutely nothing. I don't give a rat's ass about words. Evidence points to whose side is correct. Evidence
I don't give a rat's ass
points
about
to whose
words.
side is
That
correct.
is the quote of the day. The
I am
judge
going
is
to
laying
give
down
you
the
some
ultimate
time,
ultimatum here.
not a lot,
He is giving the defense
but
a
I'm
very
giving you
short
to
window,
Friday
just until
to
Friday,
figure
to
out
bring hard
what's
evidence.
going on.
This is a put
Because
up
I
or shut
want to
up
know.
moment. He
Most
is granting a
importantly,
temporary reprieve,
is
likely
it
because of the technical confusion
the
regarding the
machine
charger,
that's messing up?
but the
Are
burden
you
of proof
truly
has
charging it?
effectively shifted.
Number one.
Usually, the
Number
state
two,
has to prove
they're
guilt.
saying that
Here,
there's been
the judge is
contact.
telling the
I
defendant,
hope not.
you better prove to
I
me
want to
that you
know.
were charging it
I
or
want
you're
to
going
see
to
it.
jail.
Show
It's a
me what you
lifeline,
have.
but it's a very short
Likewise,
rope.
show
The
me what you
defendant
have
looks
too.
relieved,
I'm all
but he
ears.
should be
I'm
scrambling.
giving you, I am going to give you some time, not a lot, but I'm giving you to Friday to figure out what's going on, because I want to know. Most importantly, is it the machine that's messing up? Are you truly charging it? Number one. Number two, they're saying that there's been contact. I hope not. I want to know. I want to see it. Show me what you have. Likewise, show me what you have too. I'm all ears. I'm giving you the benefit of the doubt right now. If I wasn't, I would lock your butt up right now. But I'm giving you the opportunity now to show me what evidence is out there. Show me what you're doing. I want to know, are you charging this device as it should be? There are records of this. You know what the expectation is. I'm giving you time, Mr. McCollum, and I'm giving you the opportunity. I want to see it. Likewise, I want to see in what validation they have as well. That's it. We will reconvene here Friday because I want to know what Hunter has. I want to know what they have. Is that enough time?
Yes, Judge. Friday's fine.
Do you have any questions? You know what? It's better not that you don't. If you have any questions, talk to Hunter. But I'm giving you the opportunity. All I want to know is, are you abiding by it? Are you abiding? That's all I want to know. Okay. See you Friday. Mr. Manzano.
Yes, sir.
I brought you into court because I have bond violations yet again. Is this a third violation? Please.
May I be heard on that, Judge?
Absolutely. I just want to make sure that it is, if I'm remembering correctly, it is a third violation.
Okay. Initially, I have a pre-hearing motion for continuance, Judge. I like to have time to prepare for this. This is not a normal allegation of 19 skip tests. This young man works as a machine operator. Every day he's gone to work. This machine that he operates could cause injury to himself or to others if he is operating while intoxicated. Once we get all the work records,
because I
We are
have
moving
bond
on to a new
violations
case
yet.
now. Meet
Again,
Jesse, the machine
Is this a
operator.
third
The allegation
violation?
here is staggering. 19
please.
skip
may I
tests on his
be
interlock
heard on that,
device.
Judge?
For
Absolutely.
context,
I just want to
usually
make
one
sure
or
that
two
it
skips
is,
a problem.
if I'm
19 is a
remembering
pattern.
correctly,
The
it is a
defense
third
attorney is
violation.
using a public
Okay.
safety argument in reverse, saying,
Initially,
Judge,
I have a
he
pre-hearing
operates heavy
motion
machinery at
for
work.
continuance,
So
Judge.
obviously he isn't drinking
I like
or
to
he'd
have
hurt someone.
time to
It's a
prepare for
risky
this. This
argument.
is not
Just
a
because he hasn't crashed a
normal
forklift yet doesn't mean he's
allegation
sober.
of
The
19
judge
skip
has to weigh
tests.
the employment record
This
against
young
the
man
Smart Start data.
works
If those
as a
skips are real,
machine
this guy is
operator.
driving around without being
Every
tested,
day he's
which
gone to
defeats
work.
the entire purpose of the bond.
Judge, we could show you that there was never any reprimand, any suspension, anything from work that calls you to believe that he was operating the machine while intoxicated. In addition, Judge, I like to subpoena Smart Start records. He attempted to go over there yesterday to get records, but of course, they just gave him a 1-800 number, and then they said, well, we'll send it to you in about a week. So, Judge, this is very questionable whether or not he skipped 19 tests. In reference to the third violation, this is the third violation that pretrial filed, but the first one was that when he was released from court, he went to pretrial, and he thought pretrial was going to call him up to give him the information of where to go to get the ignition interlock. He never got that information. He was confused. And as soon as I received that email about him not having the portable device, I informed him within 5 or 6 days he had it. He's very responsible, Judge, for what he is charged with.
All I know.
Secondly, okay. Judge, that second one, it's totally shouldn't be given any credit. This is the one that he was given a drug test. He went and took his drug test. 2 days later, they notified him to come back and give another drug test.
I got it. I understand. And I certainly won't take that into account, Jesse. But I'm going to tell you now, we have here from November 27th, 2024 to December 17th, we have 19 skip tests.
Quiet, please.
Unacceptable if this is true.
I
Unacceptable.
agree 100% if it's true, Judge.
So let's do this. I'm not going to give you a lot of time, but I can give you, up to a week. We can have a hearing on this next Thursday if you'd like. And
These next 2 days, I'm not available,
records
Judge.
that you want.
Next 2 days, I'm not available. I've got my funeral going on, and we're about to leave shortly. It's in Sugar Land, and we're going to be there all day. And tomorrow at 10 o'clock, it's going to repeat. And Friday, I've got to be at the bond hearing in Montgomery County. If you allow me, Judge, I need to get records from both the company and from Smart Start.
I have those records to you today, Jesse.
For the violation dates.
The only thing I received was the allegations.
I mean, we will send you the allegation. I will send you every piece of record that we can muster up to get to you, but I'm not setting this out 2 weeks for a bond hearing. And not when we're skipping tests like crazy. I will give you a reasonable amount of time, but I'm not going 2 weeks.
May I offer a suggestion,
Judge, the coordinator is gonna be out next week and I'll be coordinating, so. Can we do it on
I'm not doing 2 weeks. This is a bond violation hearing.
May I make a suggestion, Judge? Why don't we put a ankle monitor on him? There's no way he could skip that. If we put that on, then you know if he's consuming anything.
Okay, Jesse. Just because we love you.
I love you
put the
too,
ankle
Judge.
monitor on. But I'm going to tell you now, if I get any violation, and I don't care how minute it is, I'm going to grow horns and a freaking tail.
And there it is.
Records.
The most
He
colorful
attempted
threat
to go
of
over
the
there
docket.
yesterday to
I'm
get
going to grow horns
records,
and a
but of
freaking
course,
tail. The
they
judge
just
is
gave
making
him,
it crystal
gave him a
clear that the
1-800
nice
number,
guy
and then
act is
they
over.
said, "Well, we'll
He
send
is
it to you in
ordering a
about a
scram
week."
monitor, which is an
So,
ankle
Judge,
bracelet that
this is
detects
very
alcohol
questionable
in your
whether or
sweat
not
24/7.
Skip
There is no cheating a
19
scram
tests.
monitor. You can't
In
skip a
reference
test
to
because
the
it tests
third-
you automatically every 30
The
minutes.
third violation.
This is the strictest
This
level
is the
of
third
supervision
violation
possible
that
short of jail. The
pretrial
judge is
filed.
saying,
But the
I'm letting you
first one
stay out for the
was that
holidays/funeral,
when he was
but
released
I am
from
watching
court,
your biology.
he
If he
went to
drinks even a
pretrial,
sip of eggnog,
and he thought
he's done.
pretrial was going
The
to call him
stakes
up to give
literally
him
couldn't be higher for
the
Jesse.
information.
Do you understand? You better look at every single thing that you put in your body, when you put it in, what it is. I don't care what holiday it is, and I don't care who you're with. You get a hot violation on that thing, I'm going to be hot. You understand? There's absolutely no excuse, Jesse, and I will not entertain anything if it goes hot.
I understand that, Judge.
All right, you get it today. No more excuses.
And then someone should be sending the portable report for all the violation dates showing like the window and everything to the
All right.
attachment.
Okay, we'll send them down to get it now, Jesse, but I'm up to here. Like I tell my kids.
I understand, Judge. Is it when do you want to reset this to then, Judge?
I don't know. How old is this case?
It's a date of arrest is July 6th.
So it's, we'll give you 30. At that time, though, it's time to put up.
I understand.
Okay.
He was originally on 128.
Do you want to keep the 128 day?
That'd be fine, Judge.
Is discovery complete?
Your Honor, discovery is complete. Yes, Your Honor.
Okay, so it's plea or trial on that day, Jesse, all right?
I got it. Thank
Okay,
you.
man, have a great holiday.
You too. Bye-bye now.
Bah humbug.
Mhm. I know it.
Judge, so for this violation,
So
we're gonna get this.
Continue supervision, get him the records regardless, and then he gets a scram today. Okay, all right. Good morning, Mr. Ginder. Good morning, Your Honor.
So
What's the word, Thunderbird?
I have an update, but it's not a good one. So, and credit to Amy, she's been mostly following up, but I was able to speak with the deputy sheriff in Bucks County. And right now they're spread so thin, they have no way of picking up before even the 30 statutory days. They have 4 people spread out and they have priority cases. And I explained to the sheriff's officer, like, this isn't a capital murder. This is an aggravated sexual assault of a child. This is a theft by taking. And so priority wise regarding the charge is they're just unable to accommodate. They're trying to get adult probation to figure out if there's another way to do it. But for this warrant, just be forthcoming, is that this isn't one they're going to be able to. But also it presents the issue is they're not going to recall the warrant. They still want him. They're just physically unable to do it within the statutory period. So this isn't even a discretion thing. They're just unable to do so.
So just because we still have to follow the law.
Right. And so we're stuck in this quagmire where he's going to just keep getting arrested because the warrant's still going to be live. Like he could leave today and get arrested this afternoon. It's just going to keep happening. And
Well,
so
look, you can lead a horse to water,
right.
as the saying goes. You already know
Now we have a
But I'm going to
fascinating
tell you
legal
now,
quagmire with
we
Mr.
have
Jinder.
here from
He is a
November
fugitive wanted in
27th,
Pennsylvania for serious
2024
charges,
to December
sexual assault
17th,
and theft.
we have 19
But Pennsylvania refuses
skip
to come pick him
tests.
up because of staffing issues. Imagine being
Unacceptable if
arrested,
this is
sitting in
true.
jail for 2 weeks,
I
and then
agree.
being
I
released
agree
because the other
100%
cops
if
didn't
it's
show
true,
up,
Judge.
So
only to
let's
get
do
arrested
this.
again for the
I'm
same
not going to
warrant
give
a
you a
month
lot of
later.
time,
It's a
but I can give
bureaucratic
you,
nightmare. The
up
judge
to
is
a
right.
week. We
The
can have a
warrant
hearing
will
on
never
this
go
next
away.
Thursday,
Mr.
if
Jinder
you'd
is
like.
stuck in a loop of arrests
And I
unless
can
he
Next
give
2
drives
you
days,
all
himself
I'm
to
not
the any
available,
Pennsylvania.
records that
Judge.
you
It's
want.
absurd that a
Next
state
2
would
days,
issue a
I'm not
warrant for such
available.
serious
I've
crimes
got my
and then say,
funeral going on,
sorry,
and we're about to
we're
leave
too busy to
shortly.
come get him.
That even if you get released today, that warrant will be eternally out there until you go back and hear it. Every time you get arrested, how many days are you missing in your life? 20, 30 days every single time. So the right thing to do is go back.
But I mean, that's also why he keeps getting arrested, is because every time they believe that they have the capacity to do it, and then suddenly they realize they have holiday pickups and they have other things that take priority. So that's why the warrant is still being validated, is because they think this time they can make it within.
What are you going to do?
So this one, I mean, because they've already related, and I'm relating to the court that they're unable to, is I'm not agreed to a bond, but I'm not opposed to a bond. I mean, ultimately, when it runs out the date, we run out the date, and I'm still waiting. Legally,
So
I'm waiting for.
you're not going to null it though, I guess.
I'm going to wait until I get a final confirmation from adult probation there, because they're the actual, just like for the DA's office here, for our warrants, is they're the final decider of how they want to handle the warrant. And apparently it takes a little bit of time for them to respond to the sheriff's office there. And I'm not going to waste this court's time if they're not going to respond.
Have we had him here before?
We've had him 3 times before. And so he was
Have
arrested.
we ever given him a bond?
No, we've dismissed, I believe, before it came to that. And like I said, 2 of them were before my time, before I joined general litigation. So I can't speak to when Katie and Stan did it, but at least for myself, is we dismissed it before that became a scenario.
Judge, my understanding is he was held until they maxed out their time, and then he was released 3 times.
Sure, of course. I guess that was implied, but what?
Right, it's not a day of, he's released, they max out, they
Sure.
don't get extra time, so he sat down 3 times for this. 14 days, 3 times, so 45 days, when they're not done.
At the end of the day, it's one person. That's right.
And so
I mean, it's not.
I told him, hey, he's gonna say, what's the difference this time? And he tells me he's got the funds.
No. I'm going to set a bond for him now. I'm going to give him a bond.
Right.
Yeah, I'm not going to. I mean, there's no sense in keeping you in custody when we know they're not going to come, right? But like I said, if you don't go back, this is going to continue to happen. Do you understand?
Yes, sir.
So it would behoove you to get back there as soon as possible, take care of it, so you can be done with it once and for all, and go on with your life. Really, it's nonsensical to keep getting arrested and you sit 14 days every single time. I mean, we're working 3 times now, really. Now, begs the question, what's the bond amount?
For the court, like I said, if it wasn't a parole violation, I'd probably be more comfortable just giving a number and being agreed to one. But in the end, I understand the transportation difficulties, but ultimately it is a parole violation. And so that's why I can't agree to one. I'm just not opposed to one.
Judge, I think the issue is going to be him having somebody to come and actually post a bond for him. This is a situation where they're not dismissing the case, therefore you need somebody to come.
I'm going to give you a PR bond.
Oh, fantastic then.
I mean, there's no sense in keeping someone in custody when we know that they're not going to come. It's not fair.
PR bond, I would ask for a $300 PR bond.
You know what you have to do.
Yes, sir.
Go back, get it done once and for all. I'm going to give you a PR bond now, but I'm going to tell you one time.
The judge is doing something risky here,
but I'm not setting
granting
this
a
out
PR
2 weeks
bond,
for a bond
personal
here.
recognizance to a
And
fugitive.
Not
That
when we're
means he's letting him
skipping
out
tests like
for
crazy.
free on a
It's
promise
not.
that he will
I
go
will
to
give you a
Pennsylvania.
reasonable amount of time,
Usually,
but
flight risks
I'm not
don't
going
get
2
free
weeks.
bonds.
May I
But
offer
the court's
Judge,
hands are
the
tied.
coordinator is going to
They
be
can't
out
hold him
next week,
forever if
and I'll
Pennsylvania
be
won't come.
coordinating. So
This is a trust fall by the judicial system.
can we do it on
I'm
the
not
Judge is
doing 2
banking
weeks.
on the
This is a
defendant
bond
being
violation
tired
hearing.
of sitting
May,
in Texas jails.
may I
If Mr.
suggest, make
Jinder
a
is smart,
suggestion,
he
Judge?
goes to PA and clears
Why don't we
this up.
put
If not, he's just
ankle
going to keep
monitor
cycling through the Harris County Jail every
on him?
time he gets pulled over
There's
for a
no way
broken
he could
tail
skip
light.
that.
It's a broken system, but it's
If he
the
put
only
that on,
option they
then
have.
you know.
I'm not going to continue to play this game. If you act like a child, well, we're going to treat you like a child. We're not asking for much. I'm going to give you a PR bond now, but this is a fugitive case. You get one shot. Normally, when we have people that come back on multiple fugitive cases, we don't continue to give PR bonds. We don't continue to do this. I'm going to do it now because he's already indicated that they're not going to come get you. But if you get arrested again, and if it continues to happen, you're old enough to know actions have consequences. So does the failure to act. You understand, Mr. Ginder?
Yes, Your Honor.
Okay. We'll give him a PR bond now and then just let them know. Just,
It's 14 days.
Okay.
Well, plus the one date for
but
release.
I mean, I'm releasing him now.
Right, what I mean is in terms of directives to return, because the PR bond is still within the context of the fugitive case, and so releasing for the
So
bond.
I'm
is still-
ordering you to go back to this jurisdiction, to go either turn yourself in or go post bond. Where is it, Mr. Kim?
Pennsylvania, Bucks County.
You must either go turn yourself in or post bond in that jurisdiction. If you do that, that will take care of this fugitive case. Do you understand?
Yes, Your Honor.
If you don't, this warrant, this nationwide warrant will be out there for eternity. Okay?
Understood.
Done.
Thank you, Judge.
All right.
Thank you, Judge.
So bond set at 300, Ricardo, and PR bond.
PR bond.
Yeah.
Judge Fleischer,
Yes,
you guys need to refuse first.
Oh, that's
I'm gonna come back.
true. Withdrawal waiver. He still waived, so you still have to sign. No, not him, you have to sign the withdrawal.
Oh, okay.
Good morning, Mr. Is it Diepa?
Buenos días.
Good morning.
Mr. Diepa, you are wanted out of the state of Oklahoma.
Oklahoma.
I think it's Creek County, Oklahoma, for embezzlement.
I'm so sorry. Embezzlement. Me olvidó la palabra. Perdón.
Quedaste con un cargo que no fue tuyo. Tienes el cargo, me están diciendo que te
I guess misappropriating.
I'm so sorry.
La diferencia es que
Desapropiar.
te dan la propiedad y luego te quedas con ella. No se lo quitaste a nadie, pero te lo dieron.
Mi propiedad.
Your lawyer is asking for me to set you a bond. I don't know. I've never met you before.
Lo he conocido.
I don't know who you are.
No sé quién es.
The only way that I get to know you in this very short time is by looking at you on paper, because that will tell me who you really are.
¿Quién es?
I know that you're going to tell me it's gumdrops and rainbows and that you're always walking around with a halo. But really, what matters is on paper, because it tells us how we get to know you, essentially.
Señor.
So, Mr. Kim, tell us about Mr. Diepa, please.
I couldn't find any other criminal history
Ningún otro antecedente criminal
for the defendant.
para acusado.
However,
Sin embargo,
Oklahoma has confirmed they will be picking him up tomorrow.
van a levantar mañana.
So I'd be opposed to a
Así que
bond because the
estoy en contra de una
transportation
fianza
is
por la
already
transportación.
here.
La
If they're
transportación
picking
está
him up
aquí.
tomorrow, that means
Si
they've
lo
already
van a levantar
landed in
mañana,
Houston
quiere decir
today.
que ya aterrizaron en Houston.
And it's a guaranteed transport back.
Transporte garantizado.
And for that reason, I would be
Y
opposed
por
to a
esa
bond.
razón estoy en contra de.
I have no information on the
fianza.
embezzlement.
No tengo ninguna
I
información
attempted to
en
get a hold
apropiarse.
of the sheriff's office there. They were unable to give me any information. They
pudieron dar
They
información.
did set an
Ellos sí
in-state county bond for
Ellos sí
$112,000.
112,000
Never. Always something new.
That's why I said if we have more time, then I will win by default because he will get picked up tomorrow.
Have you run an
I
NCIC?
did. Nothing else, Judge.
If I may, Judge, so first of all, my client works as a truck driver with CDL. That kind of goes with the charge that he is being charged with embezzlement. He was supposedly given something, charged with something, and there's an argument that, hey, somebody didn't get their property back or
Alguien lo
something.
recibió. se lo entregaron de vuelta.
He has a great argument for it. They showed me some emails back and forth between
Correos
him and the
electrónicos
dispatch showing
entre
that
él y el despachador
the possible bail for property
que la fianza
made
por
it
sí
to where
propiedad.
it's supposed to be. They've contacted a lawyer out in Creek County. He's got no criminal history. He's a resident. There's no flight risk. He hasn't been here before.
Contrast this with the previous case. Mr. DEA is wanted in Oklahoma for embezzlement.
All right.
And unlike Pennsylvania,
Okay, we'll send him down to get it now, Jesse, but
officers tomorrow to
I'm-
pick him up.
I'm up to
The
here.
defense is begging for a bond
Like I
just so
tell
the
my
guy
kids.
can turn himself in on his own terms. Why? Because diesel therapy,
I understand,
being
Judge.
transported
Is
in a
it
police
when do you
van
want to
across
reset
state
this to
lines,
then, Judge?
is miserable.
I don't know.
Takes
How old
days,
is
you're
it?
shackled, and you sleep in random
It's a
county
date of
jails
arrest
along
is
the
July
way.
6th.
The lawyer wants
So
to save his client that experience, but the judge has to weigh the risk.
We'll give you
If he
30.
lets him out, will
At
he
that
run?
time, though, it's time to
Oklahoma
put
is
up.
already en route.
I understand.
Giving a bond now is essentially canceling the police transport that is already paid for.
Do you want to
It's a
keep the
tough call.
128 day?
Now, I understand the predicament that somebody might be expending travel time and things like that, but my client's in jail. And so that means a lot to me and I hope it means a lot to the court. Because he's got no previous fugitive cases and he hasn't messed up in your court, I would ask that he be allowed to go turn himself in and he's got a plan to do that. I asked him, hey, what's the difference between waiting for Oklahoma? And it's easy for me to say because I'm not in there. I think we'd be in a different position if we had to wait.
You know, there's transportation. They're ready to come pick him up. Whereas one of the things that I'm going to require, I'm going to tell you now, is that his passport be surrendered so I know that he's not going to, take off and that he's can't go international. Mr. Kim, I think that's.
And unfortunately, I wish I had more facts to give you. I mean, especially with the consideration of bond for the embezzlement, it could be a couple $100, it could be $3 million. I have truly no idea what the level of, because I don't know what's in the
Does the
cargo.
teletype say? Does it tell?
It just says felony embezzlement. I don't know what the cargo is that he allegedly mishandled, for lack of a better word. I truly don't know, and that's why I have a difficult time, other than that argument.
If you want, I will, but I want the passport first.
Let me ask him if he's got access to the passport. ¿Tienes el pasaporte en donde lo puedes entregar?
El pasaporte está en mi casa.
A tu casa.
Yo tengo mi residencia en los papeles como en la billetera mía. Tengo mi residencia.
Ok, pero después quiere el pasaporte. No sería difícil para que ellos vayan.
Let's do it. I guess I'm going to let you talk because I don't want to say. I don't want him to say something.
Well, he is a resident. He is a resident. So if we have proof of that.
I don't know that.
Well, if we have proof of that, would you?
He could be Bugs Bunny for all I know. How do I know?
For what it's worth, I don't believe this particular, and other than the irony of, because it's a fugitive case, I don't believe he is an international flight risk because nothing in the teletype or for the information I have concerns with, but it's just obviously him not returning to Oklahoma in the first place. That was my concern, because it's guaranteed.
He's not a flight risk. His wife is here, his wife lives here in Houston. I think his son, tu hijo o quita afuera, un bebé es tu hijo.
You want to surrender the?
Okay, his cousin is here. The cousin's husband works with him in the trucking company that they have. And so they're all here saying to the state that they're here supporting him. He is not a flight risk because his family's here and his company's here. It's just one of those situations where he needs to figure this out and recount.
Assuming it's a one-day transport, because it was probably a two-day transport here, is he goes up one day and he still has to make the bond, the 112,000 in Oklahoma. That hasn't changed. And so, unless they argue for it up there. So either way, I don't think the time difference will be an issue because he'll be taken into custody whenever he self-surrenders.
So here, the deal is this, Mr. Diepa, is that
Esta es la situación, señor.
we give people one shot to do the right thing when you have a fugitive case. If you want me to set you a bond, I will. It has to be sufficiently high so that you know we are serious and that we expect you to go turn yourself in. We give you 2 weeks from the date of your release to go either turn yourself in or post bond in that jurisdiction. And if you do, this fugitive case against you gets dismissed. You're old enough to know that actions have consequences. And if you fail to do this, you fail to go turn yourself in, if you fail to post bond or in that jurisdiction, then I will revoke the bond here. I will set it at 0. You will not get another one. I will get a hold of you, and this time I will hold you here until Oklahoma comes and gets you. Do you understand?
Entiende.
We have a lot of people here. You already know that Oklahoma is going to come here tomorrow to come pick you up. A lot of times we have people, instead of paying the money to get out, save it to be able to hire a lawyer or post bond in that jurisdiction, because you still have to post bond over there, which is over $100,000. Here, if you post bond here, because it's a fugitive case, you are an inherent flight risk. So you will have to post most, if not all of the bond to be able to get out. Do you understand?
Yes.
What do you think of bond amount?
It's hard to say because I don't know the severity of the embezzlement, but
I mean, it's got to be high enough so that he knows we're in business, right?
I was going to say, so with the distance of it and the age, I'd say 7,500.
All right, I'll split the puppy.
Yes, Judge.
Bond is set at $5,000. You know what's expected of you. You know the consequence of your failure to act. I'm not going to play this game with you again. Do you understand? All right.
Yes, yes.
Good luck. Has he already waived?
No, and so if you want to.
He has.
Oh, sorry, he did waive, so he didn't refuse. My bad. Yes.
How much time did he have under his belt?
15th, so 3 days.
Okay, so if he does, we'll need the waiver or the withdrawal
So
waiver.
he can make that bond?
My understanding is yes, let me confirm with him.
Okay,
Just one more time.
I'll stand down. Thank you, Judge. And
What
so
a
we're stuck in this
rollercoaster of
this
a
quagmire
docket.
where he's going
We
to just
saw
keep
it
getting
all
arrested
today.
because the warrant's still going
From
to
the
be live. Like
absurdity
he
of
could leave today and
emailing
get
a
arrested this
judge and
afternoon.
claiming
It's
a
just going to
GPS
keep happening.
battery
And
just
so
died
Look,
for 3
you
days.
can lead a horse to
To the
water,
terrifying
right,
as the
horns
saying
and the
goes.
tail warning for the machine
You already
operator.
know
We also saw
that
the stark
even if you
reality
get
of the
released
justice
today,
system.
that warrant
Sometimes
will
you
be
get stuck in jail
eternally
just
out
because
there
another state doesn't have the
until you go
staff to
back
come get you.
here.
The judge balanced
Every
empathy
time you
with
get
strict
arrested, how
warnings,
many days are you
giving
missing
people
in your
second
life?
chances while
20,
making it
30
clear that
days,
their freedom
every
hangs
single
by a
time.
thread. It's a perfect example of how human,
The right thing to do
messy,
is
and
go
complicated
back.
the law really
But
is.
I mean,